This is the matter of McDonald versus McDonald, D 15-518-905D. The parties are not present. Counsel, your appearances for the record.
Russell Collins, bar number 11363 on behalf of plaintiff.
Your Honor, Christopher Tillman, 5150, here per the Indigent Defense Council. Your Honor, when I spoke to Mr. Christensen yesterday, I didn't get a name as to who I was being appointed to, and as the Court's aware, I've been appointed more than once to these new cases where we have this Supreme Court decision where if jail time is in the offing, they must have counsel. But Mr. Christensen did not tell me who the individual was. The problem is I have an indirect conflict on this case, and given the tenor of what's gone on, I just don't believe I can represent Mr. McDonald given my conflict.
Counsel, do you have anything you want to add or any questions for counsel?
I talked to counsel just before the hearing, and my understanding is he just has that he can't disclose, and I don't want to force him to disclose stuff that he shouldn't.
Oh, and but, certainly the Court's not, but you.
But I agree. If there's a potential for conflict, bias, whatever it is, based on what has already been filed in this case, I would suggest we find somebody that isn't going to have any issue whatsoever, whether it is a conflict or not. I would say we just stay as clear as
Thank you, counsel. Thank you, Mr. Tillman. I'm going to make a quick record. I'm going to ask you to stay for that. And then I'll tell you how we're going to proceed today. Mr. McDonald's accused, and you can have a seat, of abusing the process or proceedings of the court in violation of NRS 22010 sub 7 by filing with the court and offering into evidence a document knowing the same had been forged or fraudulently altered relative to an issue properly before the court, a modification of custody request. In proceedings initiated by Mr. McDonald, in the matter of McDonald versus McDonald, D 15-518-905 in the 8th Judicial District Court, Family Division, State of Nevada. For the record, Mr. McDonald just walked in. More specifically, it's alleged that Mr. McDonald abused the process and proceedings of the court in violation of NRS 22010 sub 7 on or about March 13, 2008, by filing with the court a document entitled Exhibit List, which both discussed and attached proposed Exhibit C, a letter from Nancy Sargent Hunterton, M.A., L.M.F.T., Nevada License 0988, at Character Way, Counseling, Coaching, and Consulting, addressed to the Honorable Linda Marquis, dated August 31st, 2017, knowing the same had been forged or fraudulently altered. In addition, it is alleged that Mr. McDonald further abused the process and proceedings of the court in violation of NRS 22010 sub 7 on or about March 15, 2018, by offering the same into evidence, proposed Exhibit C, a letter from Nancy Sargent to the Honorable Linda Marquis, knowing the same had been forged or fraudulently altered. Further, it's alleged that Mr. McDonald further abused the process and proceedings of the court on or about March 15, 2018, after continuing to offer into evidence, after being questioned by the court, and objections to the same from counsel about the inconsistencies and strange appearance of proposed Exhibit C. However, Mr. McDonald persisted regarding the same letter, knowing the same had been forged or fraudulently altered. This issue of contempt is unique in that the request for contempt proceedings was not made by the opposing party. Instead, the court, sua sponte, is setting this matter for hearing. The court developed serious concerns regarding the authenticity of defendant's proposed Exhibit C throughout the course of an all-day hearing, and the court posed questions and made clear to Mr. McDonald, and on the record, its concerns relative to the authenticity of that document. During the hearing, upon closer review of the underlying pleadings filed by Mr. McDonald, the court discovered that he had filed an almost identical document with the court just months early. The almost identical letter was filed with the court in the same action on September 27, 2017, and was marked as Exhibit 1 to Mr. McDonald's reply to opposition and counter motion, to plaintiff's opposition to emergency motion, to reinstate joint legal and physical custody for a regular visitation schedule, emergency motion for an order to show cause, emergency motion for reconsideration on erroneous orders, in order to compel plaintiff to reimburse Michael for the loss sustained from the improper sale of the house. A comparison of the two documents reveal that the revised letter filed in the exhibit list on March 15th and offered into evidence on March 18th contains an additional sentence at the end of the first paragraph that states as follows, quote, "I do not believe Mr. McDonald is a harm to his children or himself." This additional sentence, alleged alteration, fraudulently, strikes at the very heart of the matter pending before this court and impacts the court's primary consideration in all child custody matters, the best interest of the children. The district court has the inherent power to protect the dignity and decency of its own proceedings and to force its decrees, and thus it may issue contempt orders or sanction parties dismiss an action for litigation abuses. Further, the district court has the inherent power to prevent injustice and preserve the integrity of the judicial process. The court's ability to carry out its constitutional duty and to ensure the administration of justice was impacted, or perhaps impacted, by Mr. McDonald's actions. Accordingly, upon a finding of indigency through a review of the record, the court's appointing counsel pursuant to Mr. McDonald's Sixth Amendment rights, as discussed in the Lewis matter. Counsel has indicated that he has a conflict. He hasn't disclosed the conflict, and I'm not asking him to. However, we'll set this matter over for confirmation of counsel.
Judge, I would like to
The court is mindful of its duty to sit. However, the court is further concerned about the unique way in which this issue came to light. The court engaged Mr. McDonald in a significant colloquy regarding proposed Exhibit C, and further, it was the court that later discovered the prior version of the document filed with the court months earlier. In light of the court's interrelated, connected relationship with the allegations raised herein, which are the basis of the order to show cause, and the appearance that the connection might create, the court recuses itself from the order to show cause hearings and any other hearings that flow from the order to show cause. The court understands and has considered NRS 22030, which directs that if contempt was not have alleged to occur within the immediate view of the court, as in this instance, the court in whose contempt the person is alleged to be shall not preside at the contempt trial over the objection of any party. However, pursuant to subsection 3B, this provision does not apply to matters under the jurisdiction of family court. A review of the legislative history indicates that this portion of the statute was amended in 1999 through AB 154, which further developed and tied up loose ends in the one-judge, one-family policy to include contempt. The minutes of the Nevada Assembly Committee indicated that Barbara Buckley argued that the parties in family court utilize requests for orders to show cause too frequently, and consequently, the idea of having another judge hear these matters was allowing litigants the proverbial bite at another apple. Here, request for order to show cause has not been frequent and has not been repetitive. Further, the facts and circumstances that give rise to the current contempt allegation were discovered by the court itself during the evidentiary hearing. This was not a request for a contempt hearing by another party. The court sua sponte set the hearing, and the court is concerned about the gravity and severity of the alleged action. One judge, one family cannot be construed to inhibit the inherent authority of this court. Further, mechanical rules imposed by one judge, one family cannot imprison the inherent authority of court. Out of abundance of caution and the need for transparency, the court recuses itself. The order to show cause will be randomly reassigned.
Judge,
At that hearing, at that next hearing, in front of that next judge, there'll be a confirmation of counsel. Mr. Tillman, I know you're not representing Mr. McDonald in this matter, and I understand. Before Mr. McDonald speaks, I'm going to let you know again that anything that you say could be used against you in a future contempt hearing, and I caution you. All I'm doing today is recusing myself.
Judge,
So if there's
I would
something-
also ask that you recuse yourself from the divorce matter entirety as the prior canon violations. One, a judge shall uphold, promote, and in the independence, integrity, the impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Judge, there are so many means to recuse yourself. For one, you were the judge over my parents' case. You went to law school with my cousin Joe Bonaventure. You also, your law clerk, Connie Domingo, was also the clerk for my cousin and my uncle, and there's bad blood between them. There was no discovery done. There was a talking of your husband where you were about certain things of attorneys being shot in my case, which was discussed against attorney privilege. There's a multitude of things that you should recuse yourself under this case, and the defendant seeks an impartial party, impartial judge, an unbiased judge. And I believe I come to you on a means for custody. I haven't seen my children over a year, and my parental rights were completely terminated. Now I have no clue when I can see my kids, or no path to where I can see my children. So based on Canon 1.3, avoiding abuse of the prestige of judicial office, a judge shall not abuse the prestige of judicial office to advance the personal or economic interest of the judge or others. Judge, you also had a personal relationship with Kurt Smith, and he rewarded him $3,500. You've awarded counsel $25,000 in marital assets. All my property and over 140 in over almost $250,000 in marital losses. I'd also asked that based on Canon 2, a judge shall perform the duties of the judicial office impartiality, competently, and diligently. I say that there wasn't an impartiality, as you were caught saying you keep me up at night, and I'm going to punish you. You've also had statements of, I'm going to protect your ex and your children from you. There was no threats, there was no evidence of these things. Also believing things without set evidence. Also Canon Rule 2.2, impartiality and fairness. A judge shall uphold and apply the law, and shall perform all duties of judicial office fairly and impartiality. Judge, I did not get a fair trial. It was not impartial. The assets were not split fairly. There was not a fair trial. How could you strip parents of their own children for over a year, found due cause or unfitness? I ask that this court, based on Rule 2.3, bias, prejudice, harassment. I believe that I've been harassed by your marshals, as you can see here, 1, 2, 3, 4, 5, 6 marshals here. You've also called the Department of Homeland Security, which has also come and harassed me after trial and at the jail, and then also going and having them harass me a multitude of different reasons for that. So I ask that you recuse yourself on that. Rule 2.4, it's external influences on judicial conduct. I believe that you have a relationship with Ellen Spiegel, which is my opponent for the Assembly District 20 race. I also ask that based on Rule 2.5, competent diligence and cooperation, that you were going through a difficult pregnancy, that you might not have been on the most diligent in following those those canon rules. Ensuring Rule Canon 2.6, ensuring the right to be heard. Judge, I was shut down. I wasn't able to speak on a lot of terms, especially when I was pro se. I also asked under Canon Rule 2.3, responsibility to decide. Judge, over a year and a multitude of please, can I see my children? There was nothing decided. Rule 2.8, decorum, demeanor, and communication with jurors. This wasn't a juror, but it was a part of the defendant yelling and unprofessionalism. Rule 2.9, ex parte communications. I believe that you had ex parte communications with Judge Almasi and told her to throw the book at me. As she admitted in court that you had ex parte communications, and they discussed the contradictory orders. Canon Rule 2.10, judicial statements on pending and impending cases. I believe that you also spoke about my parents' case and the case that I had in the criminal matter. Also, Rule 2.11, disqualification. You should have recused yourself. You and Hardcastle, you guys went to law school with my cousin, my family. You might have prosecuted him. I don't know the exact relationship, but there's something there. Also, Rule 2.12, supervisory duties. I don't believe that you supervised Hardcastle on some of the orders she put in place that stripped me of my parental rights and also my property when I had a refi approved. Another thing, Canon 2.14, disability impairment. A judge having reasonable belief that the performance of a lawyer or another judge is impaired by drugs or alcohol or mental, emotional, or physical conduct shall take appropriate action and may include confidential referral. My attorney, Judge George McGlares, came in a drunken state a few times. He ended up committing suicide, and the court did not take that into consideration. There was also the reasonable consideration after Kurt Smith did not appear, and Mark Anderson took his place, which I never met previous counsel. Rule 2.16, cooperation with disciplinary authorities. Canon 3, a judge shall conduct the judge's personal and extrajudiciary activities to minimize the risk of conflict with obligations to the judicial office. I believe that you had communications with your husband regarding my case and probably my parents' case, and that there's an association there. Rule 3.1, 3.1, extrajudiciary activities in general. A judge may engage in extrajudicial activities except in prohibited by law. Participation in activities that will interfere with the proper performance of the judge's judiciary duties. A participation in activities that will lead to frequent disqualifications of the judge. Which I went to a law event where you're on the name badges on those things. There's too much conflict between this, and I believe that there is a complete sense of biasness and impartiality, and as was demonstrated in trial, where I have you deny any visitation or custody on what grounds? Based on a false conviction, a DV that's on appeal. There's no consideration as my children's rights, and they have no right to their father. They haven't seen them in over a year. And I asked, when can I see my children, believing my ex and awarding her 90% of the assets. I could go on with more of these, but I truly ask that you recuse yourself from the complete divorce matter, and that I have a reconsideration through a different judge and an unbiased, impartial judge, and based on and also that this charge of criminal charge is dismissed, as the counselor approved that letter, and you can bring her in there if you want. It's a waste of judicial time and resources, but if you'd like to, she can come and speak to what the effects are causing on me, my children, and what that letter was there for, and her secretary writing it. So that's why I asked this today, that you recuse yourself, that you disqualify from any future pleadings, and that we seek another judge that's fair and equitable, that can split our property and our children properly, not like Solomon, where when you have to go there, you don't cut the children in half. You don't give the child to cut all ties with their own father, the person that brought them into the world, that has unalienable God-given rights to their children. Judge, you are in a spot of a judicial officer. You have taken an oath of certain ethics, and that is being completely usurped in this court, and is extreme despotism. And that's why I also ask that you recuse yourself respectfully. Thank you.
Your Honor, I don't have a copy of the motion or whatever it is that he's reading. I know that he has filed a motion to recuse. It's already been heard. It's been denied. There's a lot of allegations, a lot of stuff in there. This case has been tried. It's been appealed. The decisions have all been upheld by the Nevada Supreme Court. We are here today to simply appoint him counsel, and I'm not sure why we're going through all this, but I haven't seen a copy and I have a hard time responding, other than I disagree with every allegation he just made.
Mr. Tillman, anything you'd like to add?
Your Honor, in an abundance of caution, I shouldn't.
All right. I just wanted to give you the opportunity. Certainly, Mr. Tillman indicated prior to you arriving, Mr. McDonald, for the 1 o'clock hearing, that he's unable, due to a conflict, to represent you in this matter. And so this matter will be reassigned pursuant to my order, and I'll prepare the order from today, counsel. Another status check for appointment of counsel will be heard by the new judge. Your oral request for reconsideration, for disqualification, and the other requests you've made dismissal are denied. They're not properly before the court today. There's no motion
Can I submit
filed.
the motion here, Judge, with in regards to my oral argument?
If you'd like to file a motion, I can't take the motion for you. I don't have the ability to file that for you. But you can certainly file it with the appropriate personnel in the courthouse. And counsel, you'll receive notice as soon as I do of the new assignment, and I'll make sure that everybody's noticed, and that judge will take it from here. Thank you.
So, Judge, so that it's denied?
All right.
She said 5.
All rise.